Now, let's set the record. I'm appearing in propria persona. I am not here pro se. Now, is that clear? Well, there's no difference between the two. And if you want to use semantics, Mr. Gordon, and if you want to be here in propria persona, you can be here any way you want, but you're here, okay. Thank you, Your Honor. Let the record then show I'm here pro se. Now, I'm demanding counsel, and I'm demanding counsel of my choice. And my choice is Mr. Neelis Cook, and he's here in the courtroom right now, and I would like Mr. Cook to come up and sit down with me right now so that he and I can conduct my defense in my behalf. Is he a licensed lawyer in the state of Idaho? He's 21, Your Honor. Let him answer for himself. Neelis gets up. No, Your Honor, I'm not a licensed lawyer here in the state of Idaho. Well, then, if you're not licensed, then you can't represent Mr. Gordon. Excuse me, Your Honor. I think we have a misunderstanding here of terms. Mr. Cook is not here to represent me. Well, these judges, they kind of get pompous and arrogant, They just kind of throw little fits up here on the bench, Well, what is it you're talking about here, Mr. Gordon? And sometimes they'll ask you, do you read and write the English language? No, I don't, Your Honor. That just blows them away when they do. Did you go to school? Yes, I was cursed with that affliction. I've been to the government schools, and I've still not completely recovered, sir. I'm a functional illiterate. It's difficult to throw a functional illiterate out here in the penitentiary. The Supreme Court doesn't like that at all. They don't like taking poor blacks down in the South and railroading them into a murder trial or something like that. And the guy, he's been to the third grade and he doesn't read or write and he doesn't even know what's going on around him. He doesn't even know why he can't even read. That's been going on for a long time. High courts kind of stopped that. As I said a little earlier, There's 512,000 words in the English language, Your Honor. And I only know about 10,000 of them, and that's about 2 to 3%. And I would contend that anybody that knows as little as 2 or 3% of a subject is a functional illiterate. And to illustrate my point, Your Honor, how would you like to be flying on Eastern Airlines and have the captain come over the intercom and tell you that they're having a few problems because they can only recognize 2 or 3% of the instruments, and as soon as they figure out where the altimeter is, we'll probably try to land. Just lay that on the judge sometime. Might as well have a little fun. If you're not having fun in court, you're not conducting the proceedings correctly. Now, we're on the counsel issue. Counsel is a big issue. Maybe you're in a bond setting hearing. Maybe you're at an arraignment. Well, Mr. Gordon, are you prepared to plead to these charges? Your Honor, we haven't resolved the counsel issue. How can I plead when I don't have counsel? Now, I want counsel, and I want this issue resolved. I want you to make a judicial determination. I want you to sit up there on that bench and tell me, no, you cannot have counsel, Mr. Gordon. That way I'll win the case on reversible error to the Supreme Court, because they said in Argersinger versus Hamlin that every judge will know that if you deny me counsel, you can't put me in jail. And I don't want you to put me in jail, Judge. I want you to commit reversible error. Would you please do that for me today? Well, isn't that what you're after? Aren't you after reversible error? I am. I'll take victory any way I can get it. I don't care whether the judge dismisses or the prosecutor dismisses or the jury finds me not guilty or some other way. I don't care. I'm there to win. Well, generally speaking, if you're pretty calm, cool, and collected and you approach the subject matter correctly, in this particular case, I think he denied me counsel. As I recall, that's right, yeah. Let the record show, Your Honor, that I'm moving forward against my will and over my objection without counsel, and that this court has refused me counsel, and that the court is informed of the Argersinger rule. Well, now, in that case, Your Honor, I guess we're ready for the next issue. And that's the issue of the pleadings. Are you asking me to plead guilty or not guilty today, sir? You see how that comes down? Now, that's the way I did this particular case. Now, we've covered this subject now of noticing up the court. Now, I want to go on to the next issue, but you have to notice the court up, and you have to notice your adversary. You see, what you're doing is you're calling a meeting. That's all you're doing. When you notice the court up, there's no big mystery here. If you wanted to call a meeting between you, a sales representative, let's say from a company, and a customer, wouldn't you notice up the sales rep and the customer to come into your store and meet with you to decide and discuss price and facts and figures and things like that pursuant to the sale? Well, of course you would. You know, as a businessman, you'd get your customer on the phone and you'd say, now I'm going to try to arrange a meeting with the sales rep from Ajax Milling Company. Okay, I'll get back with you as soon as I get a hold of him. You hang up and you get a hold of Ajax Milling Company and you'd say, now Ajax, can you be here on April the 10th at 1:30 in the afternoon? Yes, I can. And you get back on the phone. Yeah, they can be here April 10th at 1 o'clock. Can you make it then? You see what you're doing? Now, the judge won't do that for you. You have to do it. And the way you do it is you call the judge and you set a hearing date. And he says, I'll give you the date of the 26th day of April, 1982 at 1:30 p.m. Okay, you write that down. Got that? Then you write up this notice of hearing and you send it to the other guy. That's the prosecutor. Put it on your calendar. If he doesn't show up at 1:30, you move for dismissal for failure to move forward or failure to prosecute. That's the way that works. See how simple that is? No fuss, no muss, and no big mystery. There may be some additional rules in your particular state or county or jurisdiction that I don't know about. The way to find out what the rule is to simply call the judge's clerk and say, is that the way you want that done, sweetheart? And she'll say yeah or no, or do this or do that. Once in a while, they'll get real uppity. And they'll say, well, if you want to know, go get a lawyer. Excuse me, sweetheart, I am the lawyer in this case. And if a lawyer were to call you this afternoon and ask you how you wanted to handle it, would you get nasty, recalcitrant, and truculent with him? Would you talk to him on the telephone the way you're talking to me? Would you treat him rudely and with disrespect and total contempt the way you're treating me? That'll generally calm the judge's clerk down, and she'll come down to earth, or at least she'll come down about 10 feet or so, and then you can talk to her on a more realistic approach. Now, in the event that she won't do this, then you just go ahead and do it as best you can, you see, and document it with witnesses. Because after all, if the court casts stumbling blocks in your path, and then you fall down because you're blind, you want the next court up to know what the fools are doing to you. And in order for you to show the next court what's being done to you by the judges and the prosecutors, how they're casting stones and putting stumbling blocks in front of you, you must document it. And this is what no citizen out there in TV land does. He just blindly and accidentally stumbles along through the process, and then he's carefully and meticulously laid away. And then when he goes to the appeals process, his adversaries have carefully documented each stage of the proceedings and shown carefully that they're just righteous rosies and that they've just guarded and protected your rights at every stage of the proceedings, and that man Gordon, he refused counsel and he came into the courtroom ill-prepared, and so he fell down and he broke his nose. And that's just real sad, and we're just real sorry about that. And that's exactly what they'll do to you. So to preclude that, you have to be a little one-upsman on them. So I've had this happen to me a couple of times. You walk into the clerk's office, and they get real uppity. Well, if you want to know, then you get a lawyer. Okay, tell you what I'm going to do, sweetheart. I'm going to motion this up based upon the information that I have. And I expect you to deliver this. I expect you to file this. I expect you to do this or that. And here's your two witnesses here. See, and your two witnesses are sitting here writing this down, okay, on their yellow pads. In the event that I'm denied due process of law and found guilty, or some mischief comes because you will not tell me what it is you're demanding of me, what specific performance you want. I'm here to tell you I want to obey all the rules, and I want to fill out all the forms, and I want to do it exactly the way you want it done. And you won't tell me how you want it done, so therefore, if any mischief comes of this, you're going to be responsible for the violation of my civil rights. That could be a felony under Title 18, Section 241, or an action at law under the Civil Rights Act, Title 42, Section 1983. And I want you to know and understand that. And these witnesses here are going to testify as to your behavior and your conduct here today. So if your behavior and conduct is lawful, reasonable, and logical, you don't have any problems or anything to fear. But if it isn't, I think you should reflect upon this thing of casting stumbling blocks in my path. Now, will you take this document now? Now, see what you've done to the clerk. You see what you've done to the clerk's office, the judge's clerk. When you're in the courtroom, you do the same thing to the judge. You make him give you a judicial determination. When he changes the subject, excuse me, Your Honor, I don't believe we've decided this counsel issue. I believe that you've begun another topic here. You're trying to talk about grand juries when we haven't solved this counsel issue yet. So would you give me that judicial determination so that we can set the record, 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 so that we can set the record. You got that? Every time I talk to him, so that we can set the record, let me see if I understand the position of the court. Why do I do that? I do that so that that's almost like a red flag. You know, when the appeals court's looking at the record and they're reading through it to find out, let me see if I understand your position. One time I had a judge say, "Don't put words in my mouth." Oh, excuse me, Judge. I apologize. I don't want to put words in your mouth. I want you to put your words on the record. Would you please set the record for me? And then you just shut up. That's the closing question. Would you please set the record for me? Then he'll change the subject. I'm going to protect all of your rights, Mr. Gordon, and we're going to give you due process and equal protection and all this. Your Honor, you didn't answer the question. Will you set the record with a judicial determination on this matter of the grand jury, on this matter of the defender, on the matter of this or matter of that? Make him answer that question. Back him into the corner and make him answer that question. Now, I know that this sounds kind of redundant and foolish, and gee, who would dare talk to a judge like this? I haven't talked disrespectfully to the judge. I'm the only one that's here that's not raising his voice. And there's another key line here. When the judge raises his voice, remember that a raised voice does not come out on printed page. You must always ask the question, Judge, are you yelling at me because you're angry with me? Are you mad at me? Make him backpedal. No, Mr. Gordon, I'm not angry at all. I'm simply trying to impress upon you the seriousness of the matter. Yeah, but it scares the hell out of me, and it just sends a chilling effect up and down my body every time you raise your voice and yell at me like that and scream, and it just makes me lose my train of thought, and it just really confuses me. Would you please stop doing it? Thank you very much. You see how you do that? And you always want to remember that this judge in the opening rounds, when you're dealing with this fellow, he's dealt with hundreds of people like you. I mean, he's in that courtroom, you know. Some of these judges, I just can't believe this assembly line justice. You got to read Argersinger versus Hamlin if you want to see what the Supreme Court says about this assembly line justice. But they'll go through 200, 300, 400 people a day in some of these courts. And so you come in there and you're trying to talk law, you're trying to get reason, logic, and common sense, due process of law. And, it's hurry, 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 we haven't got all day here. Oh, well, excuse me, Judge, I don't mean to disrupt the proceedings. If you're too busy to handle me through due process of law, why don't you just dismiss the case and then take care of the rest of the sheeple over here? Or then you'll come back and say, well, we're not going to do that. Oh, well, fine. I don't mean to disrupt the proceedings in any way, but I demand all of my rights at all times, and I waive none of my rights at any time. And for that cause and reason, I demand due process of law and equal protection of the law. If I take a little longer than the average fellow over here, it's because I'm not going to give up or surrender any of my rights. And if that takes too long, I'm very sorry, I don't mean to, but perhaps that's just the way law and order is. Okay? Now, the question next to take up is, when do you write motions? Well, you'll start writing motions before you go to arraignment. Now, if you can't write motions, and that is, when you're looking at a file folder like this and all you've got is a parking ticket, I could file that much on a parking ticket if I wanted to win. You take these out of the computer. And I had a judge the other day. We have a student. He was in the courtroom the other day. This judge, he's just really upset. You could just tell. This poor judge, he's a nice guy. He just can't handle it. Loses his composure. And this young fella is in there demanding his counsel, and the judge has denied him counsel. And he says, Mr. Smedley, I find it imperative for me to inform you and to warn you that this Gordon sitting in here, why, he is not a licensed lawyer, and he doesn't know the law, and these motions, I've read these, they're out in the traffic courts, and they're all over in these courts, and he's not faced with 30 years in prison. It's you that's faced with 30 years in prison. This poor fellow, he was a young kid, and he just, what's this judge? He's almost like, a cobra, just about to pounce on some mouse, and so I'm just kind of sitting there taking all this in, and why, these motions come out of a computer, and these motions, there's no difference between these motions in this court that you're filed and then in the court that was over in the traffic court, and these motions are not even a word is changed in here. This poor guy didn't pick up on that. If I'd have been sitting there, I'd have said, excuse me, Your Honor, does the truth change from courtroom to courtroom? Are the motions that I filed lies, or are they facts? Are they, in fact, facts of law of which I want you to take judicial notice? If a fact of law is presented in 10 different courtrooms by using the identical same words, is there something wrong with that? What is it about that that makes it evil, bad, wicked, terrible, or awful? Should I take these motions then? Which motion is it that you object to? Which one of these motions in here that's written word for word with an identical motion that's been filed in some other court that you take exception to? Well, Judge Smedley over there, he overruled it and he turned it down. Excuse me, Your Honor. Let me ask you a question here. Do you think for yourself, or does Judge Smedley over there do your thinking for you? Do you have the capacity to look at, to read, comprehend and understand and make a judicial determination of and by yourself, or do you need Judge Smedley over there to do it for you? Now, this young fellow didn't have the presence of mind. He's only done, 10 or 15 lessons, and he just, couldn't get it down to that least common denominator. Here again, it's just a matter of reason, logic, and common sense. Why, that case is 150 years old. Oh, excuse me. I wasn't aware that there was an expiration date on Supreme Court decisions. I didn't know that Marbury versus Madison was overturned or that it was done away with because it's 180 years old. Excuse me, all to hell, Judge. I'm just real sorry about that. But would you tell me where I erred for my own edification? Would you please tell me what case was it that overturned Marbury? It would seem to me that if I've raised the issue of Marbury and I've relied upon it in my defense, the least you could do is to say that it was Johnson versus Jones or it was Smedley versus Smedley that overturned the Marbury doctrine. Oh, gosh, I'm all wrong and I'm awful sorry about that. I'll bet you can't find 10 cases between 1794, when John Jay took on Brailsford versus Georgia, and today that the Supreme Court's reversed itself on. If you can do that, why don't you get right on it and let me know? I read about 10 or 15 of those cases every month, and I'll notice that there are some subtle differences between them, and there's a lot of decisions made on search and seizure, but to jump to the conclusion that the Supreme Court vacillates between searches of automobiles under the Carroll Doctrine and under some other doctrine 20 years later is just pure poppycock. I'm absolutely amazed at some of the judges. This very same judge handed this young fellow a court case decided here in Idaho and said, see, our Supreme Court says you can't have counsel, or that when you waive licensed counsel from the public defender's office that you can't then defend yourself, you can't then come back later and claim that you've been denied counsel. And I took the case and I looked at it and I said it's absolutely correct and there's no contradiction. The difference is that the fellow that you're telling me about, Judge, demanded another licensed lawyer. And the court said, no, you can't have another standby lawyer at county expense. And so he went ahead and defended himself pro se. He didn't demand counsel of his choice. He didn't demand lay counsel. He didn't demand counsel pursuant to Argus-Einer. It's off point, Judge, in this case. This fellow represented himself, and he had standby counsel over there, and he had the public defender over here, and he wanted a third guy. And the court said no. And he didn't make use of the two counsels that he had, so I agree with the high court. I think that in that case, that fellow is out to lunch and off the wall. It's just absolutely amazing that these fellows can go to college and come back with that kind of warped, upside-down understanding of law. I'm not even a lawyer. I'm not a theologian either, and I think at this point I got to break here for a minute. I got to tell you this whole story because it fits right in here. I've got judges in Ada County that can't read two cases or read a case and then apply it to what's happening here today, you know. And I don't claim to be some kind of a great scholar, you know. I'm just average Joe Dokes, but when I was about 11 years old, 10, 11, 12, something like that, I was sent to a Lutheran school. It was a day school, ordinary, you know, just a grade school. I think I was in the 5th or 6th grade, something like that. And heck of a good school, you know. When you go to these parochial schools, I think you'll agree that you get a little better education. Sorry I left there and went to the government schools. I've never recovered from that affliction. And there, and you know, you had to go to Sunday school too, you know. See, if you didn't go to Sunday school, you know, you didn't get little stars on the wall over here. And, you know, I was the only kid in that school that had about 3 stars for the whole year. You know, I didn't go to Sunday school very often, and they were just always on me, you know. Oh, why didn't you go to church, and why didn't you go to Sunday school, you know? And I'm sitting there going, you know. So this one day I just, you know, I figured, well, they've been hassling me and harassing me about going to Sunday school and church, you know, that, well, I better go to Sunday school. So I showed up at Sunday school, and there's this awful nice lady. Her name was Mrs. Ray. She's probably dead by now, you know, and she, you know, wouldn't care if I used her name anyway, but she's just a super nice lady. Just one of those kind of nice ladies that just, you know, goes to church, and she's just a wonderful person. And she had a couple of boys who were in school there, and they were just, you know, they went to church every Sunday, and they were just upstanding pillars in the community, and just fine folks, just real nice. And the lesson that week was about, see if I remember this now, the lesson that week was about the parable of the sower, and they have these little worksheets, and they pass it out, and there's these pictures in here, you know, in the Sunday school. You've probably seen these. And we went through this lesson, you know, on the parable of the sower, you know, and Christ was speaking in parables. And he'd say, well, this guy goes out here and he throws the seeds out on the ground, and it falls on stony ground, and it springs up, or it doesn't, you know, doesn't root or something. And he goes on and he gives about 3 or 4 examples, you know, analogies we call those today, and they're called parables there in the Bible. And some kid in there is saying, why did Jesus speak in parables? And Mrs. Ray, nice lady. Well, you see, in those days, those people were just simple folk, and they didn't go to school like we do today. And those poor farm people in those days, they just didn't understand how to read and write like we do today. And so Jesus was trying to save their souls from hell, and in order to do that, he spoke to them in parables so that they could understand what he was talking about. You see, if he would have just gotten up there and started preaching a sermon, they might have missed the point, and they might not have understood it, you see, and they might have missed their salvation. And she just went on for about 5 minutes. She just really laid it out so that everybody could just understand it, and it was just as plain as day that Jesus went out and spoke in parables so that those people could understand it, because they were dummies and they hadn't gone to school, and, you know, we left, and I don't know, something happened. It doesn't happen very often. I opened up the Bible, you know, and I wanted to read that. I read it in the Sunday school lesson. I thought, gee, that's interesting. I think I'll just read it over here. You'll find that in Matthew 13. It's called the Parable of the Sower. And over here in Matthew 13:10, there's a question asked. And his disciples came and said to him, "Why do you speak to these people in parables?" The identical question that this little kid asked the Sunday school teacher said, "Why did Jesus speak in parables?" And so his disciples came. And here it is in verse 10. And the disciples came and said to him, "Why speakest thou in parables?" And he answered and said unto them, "Because it is given unto you to know the mysteries of the kingdom of heaven, but to them it is not given." No, I'm only 11 years old, and I'm dumb as a post, but it looks like to me in plain language he says, I spoke to them in parables so they couldn't understand the meaning of the mysteries of the kingdom of heaven. I don't want them to know it. It's that simple. Now, I don't know what that means to you. I'll just leave it to you. You read it, and you figure out for yourself what it means. But when I read a Supreme Court case, and the guy says in there, you know, some judge will say, the issue before us today is the issue of due process of law. I don't have any problem with that. You know, I can say, oh, I guess what this case is about is due process of law. Right up in the beginning of the case, it'll tell you plainly. Judges don't even like to read the paper that we put in. You take a look at these and you tell me what you see. You know, here's your eyeball and you're reading this case. I filed all of this paper in the court. And there are some motions in here. Here's a jurisdiction brief, rights in support of demand for dismissal. I don't know what number that is. Turn over there with me, would you? Received June 25th, 1982. It's about, a third of the way through. It's not very far in there. Let's see if we can get a number on that one. Some of these numbers didn't come through too well. You start off there with number 12. You can tell this is an extemporaneous TV show, can't you? Looks like 28 is on notice and demand for dismissal for want of jurisdiction. Looks like number 28. Okay. Then it must be number 29. Looks like the next one here. Here's a jurisdictional brief. Here's a brief. I filed a motion. I'm saying, Judge, you don't have jurisdiction in this court. You're off the wall, out to lunch. I want you to dismiss. And so I filed this. Now look, the very first words in here, it says, Article 1, Section 3 of the Idaho State Constitution states. And there's a quotation there. And it says, the state of Idaho is an inseparable part of the American Union, and the Constitution of the United States is the supreme law of the land. I put that in there. And this judge says, well, there isn't a single word in there that changed from the time that this guy Gordon filed that motion over in the traffic court. And here you're faced with 28 years in prison, or 30 or whatever it is. Well, what did you want me to do? Re-edit those words? Did you want me to say something different? Did you want me to take the Constitution and rewrite it? Does it change? Does the Constitution change? Is it a lie over in the traffic court and the truth today in this court? Is it a lie today in this court and the truth over there? What the hell difference does it make if you filed the same motion in every court in the United States? Does it change anything? I don't even understand the logic behind a judge who would say, this motion is identical to another motion and I've already read it. Wonderful. If you've already read it, is it the truth? If it isn't the truth, it must be a lie. If it's a lie, would you please tell me where the lies are, where I've been deceived? Would you please tell me, Judge, how I've been taken down the primrose path and deceived? And if you'll do that and show me where this guy Gordon is just gouging me, you know how much I'm charging this kid? I'm not a licensed lawyer, so I can't charge. I'm in there free of charge. I wished I'd have been sitting up there. This kid's got this public persecutor over there. In 3 months' time, that public persecutor never filed even so much as one piece of paper in the court. That kid filed 22 motions in the first 28 days. Now tell me who's working for that kid. I didn't file them for him. I just pulled him out of the computer and said, here's an issue of rights. Your rights are being violated, boy. Let me show you what your rights are. This kid didn't even know he had rights. This kid's been to the government school. Now what I'm trying to illustrate for you is this, that when you're sitting there in the courtroom and some judge says, well, this came out of a computer. What the hell difference does it make if it came out of an IBM typewriter, out of a computer, if it came off of an old Banger typewriter? What difference does it make if Oliver Wendell Holmes first filed this motion in 1922? I don't understand, Judge. What is it about this motion or this brief or this affidavit that makes you feel like that it isn't worth your time to read? When the guy says it's specious and it's without foundation and without merit, do you ever ask the question of the fellow, explain this to me? You say it's specious. How is it specious? What is it that is subtly deceptive about this particular doctrine? On what page is it? Is it on page 4, paragraph 2? The powers of our government are supposed to be severely limited, and this has been best presented by the Chief Justice of the Supreme Court in 1803. Is that specious, Mr. Prosecutor? Is that a specious statement up there, Judge? Are the powers of our government then severely limited, or aren't they severely limited? Do you have unlimited power in this courtroom, or do you have limited power, Judge? Am I lying to you when I tell you that you have limited power? Is this frivolous? Are powers a frivolous subject? Do you assume power that is rightfully held by someone else? Do you assume the powers of the legislature and pass law? Do you assume the powers of the governor and execute? Or do you work within the doctrine of the separation of powers, Your Honor? Why don't you ask some of these jurists and some of these persecutors and public prosecutors, and why don't you ask them, well, what is it about this? I did that. I just looked into the Scripture, and I think that what's happening is you've got the same old problem with people quoting Scripture that you have with lawyers and jurists quoting law. What Christ said in the Bible and what the Supreme Court says in Washington is not adhered to at the lower levels. You get down here to the local church, and the preacher, or the preacher's agent here, in this case Mrs. Ray, says, well, he was speaking in parables because those poor people didn't go to school and couldn't understand. Christ said, I spoke in parables because I don't want them to understand. You got the Supreme Court over here in the United States. They sit here and they say, the powers of the legislature are defined and limited. And this judge over here in the district court says, I've got unlimited power. You're not going to get a grand jury, and this information is sufficient. And he just makes his decisions in absolute diametric opposition to the plain, easy to understand statements of the Supreme Court or of the state Supreme Court over here, just making themselves a law unto themselves. And then they will point their fingers at you and say, Mr. Gordon, it's obvious that you're not competent to conduct your own defense because you don't understand the law. The law is difficult to be understood, and the law has to be used by a trained mind from law school. And that's why you're off point here, Mr. Gordon. That's what they tell me. Tell it to me every day. I imagine if I would have challenged that nice lady, she'd have sat there and said, "You better go to the preacher over here and get your mind unscrambled, you dummy." Well, now that's what you're up against, and it's about time that each and every one of you recognize that when you file motions and briefs and arguments, etc., you get into the courts, they're going to laugh at you and make fun of you and ridicule you, and they just go on and on like this. But I noticed that in 33 attempts, I've won 33 times. Now, that doesn't mean I'm going to win every time. One of these days, I think they'll probably do like they did Christ. You know, he was a pretty good lawyer. Yeah, that's right. This Bible is a law book. It's a book of law. Now, I didn't write it, so I don't take any credit. So don't anybody get mad at me, you know, if I quote Scripture once in a while. The reason I do that is our founding fathers believed in Scripture, and they wrote our Constitution, and the foundation of our nation is based upon Scripture. I didn't make it that way. I'm just telling you that's the way it is. Now, that being the case, then, it would seem to me that we citizens need to know and understand law in the same way that Christ knew and understood law. Do you know that they charged him with treason? If Christ were alive today, he would be a felon today. A convicted felon, they would call him. And they would not let him carry a gun, and he'd probably be on probation. Paul was cast into prison numerous times. Do you know that today, if he were walking around in the United States of America, his picture would be in some file, his mugshot would be in some police rogues gallery? Do you know that Peter was in prison? Do you know that Peter could not preach today? If he went down to get a license from the state to preach, I don't think he could get one. I think his character would be so assassinated by the term that he spent in the dungeon. And with the other criminal elements that he keeps company with, this Christ and this Paul, who are convicted felons themselves, that Peter could not preach. And what about these other fellows like John and Stephen and these other citizens who were going in and listening to these people? Does that strike you of IRS agents running around taking license numbers of you people out there who associate with criminals and felons like me and others? Well, I'll leave it up to you to decide. All I know is that a man that stands up and demands his rights like our founding fathers did will find themselves on the run and persecuted and hounded and thrown into jails, and their character and their livelihood taken from them. Every one of those signers of the Declaration of Independence, with the exception of 2 or 3, lost their fortunes. They sure as hell weren't in that revolution to make money. And I've got judges up here running around telling people that Gordon over there, he's just leading you down the primrose path, charging you money so that he can line his own pockets, and you're the one that's faced with jail. I wished I did get paid for some of the time, effort, and energy I put into some of these cases. But if I did that, I'd have to be a lawyer. And if I did that, then I'd have to practice law. And if I did that, well, I don't want to make any snide or nasty remarks, but I'll just leave it to you. You show me in Scripture one good word about a lawyer. Would you?